Good evening, everyone. We've had a couple of orders hit the docket from Judge Liman. He's kind of when I'm looking at what's coming down now, because there's so much is being put out, stuff that's been outstanding for a long time, and he kind of looks like a heavily pregnant woman who's going into nesting, right before they go into labour. And I feel like he's doing a lot of housekeeping and getting the docket in order ahead of his rulings on the, motions for judgment on the pleadings and the summary judgment, and ahead of the pre-trial motions. So the first two, I'm not really going to read in any depth the first two because they're that old. Actually, they're kind of redundant, really. The first one is concerning the content creators subpoenas. Not all of them, but Sweet and Salty Lynn and Cassidy and Perez. There's a couple of Jane Does as well. And it's, motions basically to proceed anonymously, etc., which he's like gone, yeah, okay, you can proceed anonymously, but there's nothing to proceed with because the subpoenas have actually been withdrawn. Motions for sanctions and protective orders, they were denied for lack of standing. And again, kind of moot now because all of the subpoenas have been withdrawn. There is one from this person who's causing, I suppose, a little bit of confusion and head scratching amongst the content creators. This J. Alexander Townsend, who is, I don't know, he says he has a subpoena. He won't identify which subpoena or what name it's under or even which platform. But which would then make it really hard to ask a judge to quash it if you can't identify it. But obviously his motions have been denied too. Just because, again, it's all redundant. Yeah, that's pretty much that for that. Then we also got the amicus brief, the motion to file an amicus brief by Thomas Carver, which is a very nice thing to do, but it's actually been denied. Now, one of the things that Judge Liman kind of he cited here from another case is that normally an amicus brief would only be allowed when a party is not represented competently or represented at all. Now, obviously, both Wayfarer and Blake Lively, for that matter, are sufficiently represented. You can say what you want about her lawyers, but they are doing their job, not necessarily ethically, but they're doing their job, and she's got representation. So Thomas Carver is obviously, his request to file an amicus brief has been denied because Wayfarer, effectively, they don't need it. They're represented well enough. So I'm hoping Judge Liman will apply the same logic to the flurry of, virtue signaling charities who filed amicus briefs for Blake Lively. He may not say anything about them at all, in fairness. He may just ignore them. He has not taken them into consideration. Unless he says something about it in his decision on her Rule 47.1 remedies, which that may be coming soon as well, given all of this. But the big news is Leslie Sloane filed, we all remember, she filed a motion to recover her attorney's fees and costs. So I'm going to just quickly go through some of this. It's not a particularly long order. No, it's not a long order. It's about 10 pages. Okay. Consolidated defendants Leslie Sloane and Vision PR and Consolidated Defendants Leslie Sloane and Vision PR moved pursuant to Federal Rule of Civil Procedure 54D, New York's anti-SLAPP law, and the court's inherent powers for an award of attorney's fees and costs. I won't go through the background. We all know the background. Just going to go straight to the discussion. Okay. Sloane moves for attorney's fees and costs under New York's anti-SLAPP statute and the court's inherent powers. New York's anti-SLAPP law is intended to deter actions filed to punish or harass a defendant for participating in public life. Among other things, it permits a defendant who has been sued in a covered action to recover damages, including costs and attorney's fees, if such action was commenced or continued without a substantial basis in law or fact. Two provisions of New York's anti-SLAPP statute are relevant here. First, New York Civil Rights Law Section 70A1 provides a defendant in an action, let's just make this a bit bigger, a defendant in an action involving public petition and participation as defined in paragraph A of subdivision 1 of section 76A of this article may maintain an action, claim, cross-claim, or counterclaim to recover damages, including costs and attorney's fees, from any person who commenced or continued such action, provided that costs and attorney's fees shall be recovered upon a demonstration, including an adjudication pursuant to subdivision G of Rule 3200-11 or subdivision H of Rule 3200-12 of the Civil Practice Law and Rules, that the action involving public petition and participation was commenced or continued without a substantial basis in fact and law, and could not be supported by a substantial argument for the extension, modification, or reversal of existing law. New York Civil Rights Law, Section 70A1, Second Subdivision G of New York Civil Practice Law and Regulations, Section 3211, referenced in Section 70A1, provides in pertinent part stay of proceedings and standards for motions to dismiss in certain cases involving public petition and participation. 1. A motion to dismiss based on paragraph 7 of subdivision A of this section, in which the moving party has demonstrated that the action, claim, cross-claim, or counterclaim subject to the motion is an action involving public petition and participation as defined in paragraph A of subdivision 1 of section 76A of the Civil Rights Law, shall be granted unless the party responding to the motion demonstrates that the cause of action has a substantial basis in law or is supported by a substantial argument for an extension, modification, or reversal of existing law. The court shall grant preference in the hearing of such motion. 2. In making its determination on a motion to dismiss made pursuant to paragraph 1 of this subdivision, the court shall consider the pleadings and supporting and opposing affidavits, stating the facts upon which the action or defense is based. No determination made by the court on a motion to dismiss brought under this section, nor the fact of that determination, shall be admissible in evidence at any later stage of the case or in any subsequent action, and no burden of proof or degree of proof otherwise applicable shall be affected by that determination in any later stage of the case or in any subsequent proceeding. 3. All discovery, pending hearings, and motions in the action shall be stayed upon the filing of a motion made pursuant to this section. The stay shall remain in effect until notice of entry of the order ruling on the motion. The court, on noticed motion, and upon a showing by the non-moving party, by affidavit or declaration under penalty of perjury that, for specified reasons, it cannot present facts essential to justify its opposition, may order that specified discovery be conducted notwithstanding this subdivision. Such discovery, if granted, shall be limited to the issues raised in the motion to dismiss. Okay. Section 3211A7, referenced in Section 3211G1, is New York's corollary to Rule 12b6, and it provides for dismissal of a complaint where the pleading fails to state a cause of action. Section 3211G1 to 3 was enacted by the New York legislature to provide a vehicle through which defendants could expeditiously halt SLAPP claims and recover attorney's fees and costs without the burden of protracted litigation. The Sloane parties assert that the New York Anti-SLAPP statute applies and its elements are satisfied because Sloane's alleged statements regarding sexual misconduct concern the public interest and Baldoni is a public figure, and the claims lack a substantial basis in law and fact, which entitles them to reasonable attorney's fees and costs in the approximate amount of $1,300,000 in fees and $38,000 in costs. They assert in the alternative that they are entitled to their reasonable attorney's fees and costs pursuant to the court's inherent powers. The Wayfarer parties respond, 1. New York's anti-SLAPP law does not apply to the Wayfarer's defamation claims, which the court evaluated on the motion to dismiss by applying the law of California. 2. New York's anti-SLAPP law does not apply in federal court. 3. The Sloane parties cannot obtain relief under New York's anti-SLAPP law by way of a motion filed in federal court supported by the court's decision to grant the Sloane parties' motion to dismiss pursuant to Federal Rule of Civil Procedure 12b6. And 4, their complaint was not filed without a substantial basis in law or fact. The Wayfarer parties also assert that Vituska's credibility is suspect. I mean, that's putting it mildly. That guy has changed his story more times than Blake Lively's changed her story on what happened in the trailer with Jamie Heath. I think that's being very, very generous to call his credibility suspect. But okay. Tellingly, the Wayfarer parties do not dispute that Vituska told them before they filed the complaint that Sloane had not made the allegedly defamatory statement. The court has concluded that the Wayfarer parties' argument that the New York anti-SLAPP law does not apply in federal court is without merit. There is an emerging trend of cases favouring the application of the substantive standards of the New York anti-SLAPP statute in federal court. The court now joins that emerging consensus. The substantive provisions of the New York Anti-SLAPP statute do not violate the Rules Enabling Act or conflict with a federal rule of civil procedure. The court can put it no better than Judge Rochon did in Halebert. To sum up, New York's anti-SLAPP law is doing no procedural work in the instant case. It is merely defining the substantive standard for entitlement to a state law remedy. Plaintiffs are not relying on the New York anti-SLAPP regime's expedited motion to dismiss or summary judgment mechanisms. They are asserting affirmative claims based on a substantive cause of action created by the New York legislature, a routine exercise in federal diversity cases. I can feel my voice going again. In this context, Section 70A's substantial basis language does not supply a pleading standard. It is a substantive provision that impacts the rights and obligations of individuals within a given jurisdiction and does not answer the same question as Rules 12 or 56. Accordingly, a federal court sitting in diversity must apply Section 70A because it is a substantive rather than a procedural provision. The court has no occasion to consider whether New York or California law applies to the Sloane party's anti-SLAPP claim. that the substantive provisions of the New York Anti-SLAPP law may be applied in federal court without violating ERIE does not mean that the procedural rules of Section 3211G1 to subsection 2, permitting anti-SLAPP's costs and attorney's fees to be pursued by motion, apply in federal court any more than the stay provided by Section 3211G3 applies in federal court. Federal Rule of Civil Procedure 11, not Section 3211G, is applicable when a motion is made for sanctions based on frivolous litigation in federal court. Rule 11 requires that a factual contention must either have evidentiary support or, if it does not, be specifically identified as an allegation likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. It also provides for sanctions if a pleading is made for an improper purpose. If a party wishes to obtain relief in federal court under the New York Anti-SLAPP statute, he or she must proceed by way of an action, claim, cross-claim, or counterclaim. Sloane alternatively seeks sanctions under the court's inherent powers. Sloane's submission, if credited, outlines a potentially troubling course of practice by the Wayfarer parties or their counsel in this court. They allegedly filed a false claim in this court by claiming that Sloane told Batuska that Blake was sexually assaulted. Are we on first name basis now? Blake. They allegedly filed a false claim in this court by claiming that Sloane told Batuska that Blake was sexually assaulted despite receiving text from Batuska prior to filing that affirmatively stated that Sloane made no such statement. In doing so, they made Sloane collateral damage in their battle against Lively. The court has inherent power to impose sanctions for bad faith conduct, even when the conduct could also be sanctioned under the statute or the rules. Is he inviting her to file a Rule 11 motion for sanctions? Sounds like he is. However, the court must exercise caution in invoking its inherent power, and it must comply with the mandates of due process, both in determining that the requisite bad faith exists and in assessing fees. When there is bad faith conduct in the course of litigation that could be adequately sanctioned under the rules, the court ordinarily should rely on the rules rather than the inherent power. In this case, Sloane could have followed the procedural requirements of Rule 11, served a copy of the sanctions motion on the Wayfarer parties, and given them an opportunity to withdraw the allegation, and then, only if the allegation was not withdrawn, filed a motion for Rule 11 sanctions. The timeline in this case confirms that Sloane could have pursued that course. On April 30th, 2025, Sloane filed a discovery motion that included, as an exhibit, the December 2024 complaint filed by the Wayfarer parties against the New York Times in California State Court, which included at least one of the text messages from Batuska that Sloane alleges demonstrates the falsity of the allegations against her. Sloane obviously had personal knowledge of what she said to the Daily Mail. If she believed that the Wayfarer parties had engaged in sanctionable conduct, she could have raised it with them, and then with the court under Rule 11. She chose not to do so. Okay. So you're not inviting her to do it. You're saying, well, you had this, remedy open to you, and you did not take it. In this case, thus, the court will not allow inherent powers to substitute for the procedural mechanism under Rule 11. All right, now that all makes sense. The motion of the Sloane parties for attorney's fees and costs is denied without prejudice to renewal by way of a formal action. So he is kind of saying, right, you need to bring the formal action, similar to what the New York Times have done. Okay. I mean, it's denied, but Do I think she'll resurrect it and bring it as a formal action? Yes, I do. I do think that's going to happen. Okay. That felt a bit like it was begrudgingly denied. Like, yeah, it just felt a little bit like he denied it, which is the right thing to do. But if he could have found a way to give it to her, he would have. All right, guys. Take care.